Welcome back, everyone. Sheepdog Smokey here, and thanks for joining in again. Before we begin, as always, please remember to like and share the video, as well as to subscribe and turn on notifications so that you're among the first to know of all new content as it's posted. Now, this one honestly is a bit of a surprise for a couple of reasons. One, it would seem that Supreme Court Justice Ruth Bader Ginsberg is back in the main chambers after her health scare in 2018. It was rumored she was working only from her office and was basically communicating everything through aides and through clerks, which for a Supreme Court justice, or any judge really, that should signal a time for them to retire. But this one apparently is now pointing to her being back in the courtroom hearing arguments, which, if that's true, that's where she should be, so this is a good thing. But it also surprised me in the ruling itself, because she has been known in very recent years to have gotten more and more and more liberal as everything goes on. Now, the article itself talks about how the Supreme Court found on Monday that a criminal defendant can be sentenced for violating his supervised release even if the release expires while he is incarcerated ahead of facing new charges. Now, I realize that may sound like Greek to a lot of people, but having been a detention officer myself, I have actually supervised people while they're waiting to go to trial for a variety of reasons. Basically, what it says is that you are charged with a crime, you go to court, you're convicted, you go to jail, and you have supervised release. Parole is a form of that. A halfway house is another. Home arrest is another. But basically, you're not completely free after you're released from prison. There are conditions. You're not allowed to drink. You're not allowed to associate with certain people. You're not allowed to go certain places. Things like this. Almost all of them have a stipulation that you're not allowed to travel more than a certain distance from either your home or the halfway house or another central location, so that you are always available should your supervisor need to speak with you. And in this case, we have Jason Mont, who violated that and was arrested, and while awaiting trial for the charge of violating his supervised release, that time ran out. Now, to give you a cut down version of this, let's say you go to jail for DUI. It is not your third strike. So when you get out, after your 60, 90, 180 days, whatever you're charged with, but we'll say that you reported to prison on January 1st and you were serving 180 days. So you're out roughly end of June or July. So we'll go with just a normal July 1st, you're out. And you have 2 years of supervised release where you're required to go to AA. You're required to check in with your supervisory officer. You're not allowed to drink. You're not allowed to be at a bar. Not allowed to associate with certain people. Now, let's say that was in 2015. And you had 2 years from July 1, 16. So you're released in 2016, July 1, you have 2 years. In June, we'll say June 20th of 2018, you're 10 days from the expiration of your supervised release. You go to the store, you get a beer, and you are observed by someone who knows you, and this is reported to your supervising officer. You're not allowed to be in possession of alcohol. You are arrested for violation of supervised release. You're arraigned the day you're taken in, June 20th, but you're not actually brought to court and the official court hearing heard until July 15th. You argue that it doesn't matter that you violated your supervised release. It matters that I wasn't on trial before the supervised release happened. It's a stupid argument. The fact that we have 4 people. So basically we have And Neil Gorsuch upsets me here, but Neil Gorsuch, Sonia Sotomayor, Stephen Breyer, and Elena Kagan argue that it doesn't matter that you broke parole. It doesn't matter that you violated a court order. If the court is not able to completely hold the new trial before the end of supervised release, then you go free. This is an invitation for people in cities like Los Angeles, Chicago, New York, Dallas, Seattle, where they know you're not going to actually have a trial for possibly 3 to 4 weeks or longer. So let's set this in New York City, Manhattan. And let's say that you are 95% certain that you won't get a trial after arraignment for 4 to 5 weeks. So your supervised release ends in 3 weeks. You go out and get drunk. You don't drive, so all you did was violate your parole by getting drunk. You're brought into jail, and this is where you would stand up in the middle of the night at midnight, call for a guard, and say, my supervised release has ended. You now can't charge me with violating it because it's over, blah, 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 blah. But the thing is, they're not holding you until after your supervised release ends to charge you. You've been charged. You see, this is what this article doesn't bring up. You are arraigned within normally 48 to 72 hours or less. Now, I worked in a county that was not nearly as busy as even Dallas or, say, Orange County, as opposed to Los Angeles or San Diego. So we were a large area, but we weren't as busy. We had judges on call 24/7. Now, granted, normal weekends, so from 5 o'clock Friday night till 8 o'clock on Monday morning, you could sit for that 48 plus hours, okay? 63 hours. You're not in jail 3 full days, but you sit in jail for 63 hours in holding if there is no judge that can come in on the weekend, and there were plenty of them who would. You are arraigned. You are officially charged. So the only way this guy could actually make a logical argument is that he had a beer at 11:30 at night on June 30th, and his supervised release ended July 1st at midnight, or at 12:01. So he went out to a bar, didn't get there until 11:30, and had a beer, and got drunk in 30 minutes, which is stupid. In fact, we'll leave that out. He went to a bar, which was prohibited, and he had a beer, which is prohibited. Now, someone there recognizes him, calls his parole officer. Parole officer arrives at 11:55. On the drive to the police station, the guy might have tried, it's July 1st, you can't charge me, which is also a stupid argument. This is like saying, because it's now a different date, you're not allowed to remember that I did something illegal. And I just don't understand how anyone can make this argument. Okay? If I was told I could not go to, I don't know, a local library, and I'm seen walking through the parking lot as I walk home from work, I would argue that I would not argue that you can't charge me because my time has expired. I would argue that I did not break my supervised release. I would say I'm walking home from work. I did not enter the library, and I was not going to walk in the street where it's dangerous. I chose to walk through a parking lot so that I would be safer. That's a valid argument in my book. Also, it's one where a police officer who knows you might say, hey, what you doing? And when you say, hey, I'm walking home from work, and they might say, you weren't just in the library, were you? Nope, wasn't in there. You can check the video records. Most of the cops I know, and I'm saying most as in 99%, wouldn't even delay you further. They might go in and check the video, but you're just walking through a parking lot. This is someone who will use that same logic. They're not allowed to go to a public library. And yes, I realize it's out there, but we're going to use it. And they're not allowed to go to a public library until July 1st. But we'll say July 1st happens to be a Sunday. And they really want to get a book. So they go to the library on Saturday. They're arrested Saturday night at their home. They're not arraigned until Sunday morning. Look at you can't charge me. You can't even you can't do anything because my time has expired. That's not what happened. That's not in any way a logical statement. The statement is from date X, July 1 of 2016, to date Y, July 1, 2018. From those, for that window, July 1, 16 to July 1, 18, you are not allowed to do these things. You did one of those things during that time. It doesn't matter if they didn't bring it to trial during that time. Just doesn't matter. This is the same as telling your teacher that because she got sick and there was a substitute in class collecting the assignment due on Friday, but you didn't turn it in until Monday and you're now being docked points. Well, I couldn't turn it in because you weren't there. Yes, you could have. This is a classic, I'm never at fault. It's not my fault. It's everyone else's fault. And it is a stupid argument. But I've gone on long enough about it. Let me know what you think. Just remember, keep it civil. We don't learn from argument, we learn from debate. I would love for some attorneys to chime in on this because my experience is limited. I was the guy serving on the pod, making sure people made their beds and cleaned up their junk off the table, ate dinner quietly, and behaved. And I was the one calling them, hey, you got to go, hey, you got to move. I just know what I heard. And I know what my own logic tells me in this situation. So if you have an attorney friend, I would love to get some feedback on this and to actually have a discussion. But in the meantime, again, remember to like and subscribe and share the video as well as turn on those notifications. And until next time, everyone, have a wonderful day.